Good evening, everyone, and thank you for joining us for the Pennsylvania Oil and Gas Legal Update for 2020. In just a moment, attorneys Robert Burnett and Brendan O'Donnell are going to talk to you real quick about what's going on in Pennsylvania with oil and gas. You will note as attendees, you are all muted currently. That is just so these guys can get through their presentation. After the presentation, we're going to allow you to enter some questions via the chat. If you look at the bottom of your screen, there is a chat pop-up that will pop up. Just click on that. You can type in your questions. We'll compile them all, and Bob and Brendan will go through them and answer them afterwards. If you have any technical errors or issues during the presentation, please just also put those in the chat. Send them only to me at Houston Harbaugh, and I will try to work through those with you as we go through the presentations. So without further ado, I think we've got a lot of people on board now, so we'll get the presentation started.
Thanks, Megan. Thank you very much for helping us put this together. Hi, everyone. My name is Bob Burnett. I'm an oil and gas attorney here at Houston Harbaugh, and my associate, Brendan O'Donnell, is also online with us here. And I wanted to thank everyone for joining us this evening and taking time out of their day to attend this virtual town hall. You know, I enjoy getting out and about across Pennsylvania and talking to landowners about oil and gas matters and hearing their questions, addressing their concerns, and just talking about oil and gas law. But with COVID, we're not able to do that. And so we're trying to get out and reach landowners through this platform, and hopefully it works. Be patient with us. It's the first time we've done it, but we're excited to have this opportunity to talk oil and gas with you. You know, COVID's changed our lives, and it's changed our daily routines. But one thing it hasn't changed is oil and gas law. And cases are still being decided, leases are still being negotiated, royalties are still being paid out. This is all still happening in light of it, despite COVID. So it's important for landowners to stay up to date on what's happening and understand where Pennsylvania law is going on these important issues. So tonight, we're going to talk about 4 topics. We could probably talk about 50, but we picked 4 topics that we think are very relevant and germane to landowners across Pennsylvania. Topic 1 is going to be hydraulic fracturing and subsurface trespass, and the landmark decision in Briggs that was issued earlier this year. Even though it was issued back in the winter, it is still very important that landowners understand the effect and reach of that opinion and how that area of law is still evolving in Pennsylvania. So we're going to talk about cross unit drilling and Act 85. This is a huge topic. It's a hot topic that I believe is going to be even more important throughout this year and next year as more and more drillers elect to drill multi-unit wells or cross unit wells. Then we're going to talk about lease expiration. There was 2 decisions. One decision that came out from the Superior Court that I think is controversial and incorrectly decided. And then there's also a case that the Supreme Court of Pennsylvania has decided to hear further argument on. So 2 important cases that are going to impact landowners' potential lease expiration claims. And then finally, we're going to discuss briefly the deduction of post-production costs and a case that came out of Kansas that I believe will be instructive to landowners here in Pennsylvania that have market enhancement royalty claims. So without further ado, let's jump right into topic number 1, the Briggs decision. I assume everybody on this virtual town hall has some familiarity with Briggs, or at least heard about the decision. It was probably the biggest oil and gas decision in the United States over the last 15 years, and it was here in Pennsylvania. Brendan and I had the privilege and the honor to actually be involved in this case. We submitted an amicus brief on behalf of the National Association of Royalty Owners, Pennsylvania chapter. So we were able to write a brief and present argument to the Supreme Court. It is an important decision because it addresses the interplay between 2 fascinating concepts, the rule of capture and subsurface trespass. And then you sprinkle in the notion of hydraulic fracturing and horizontal drilling, and you have a intellectual challenge, getting all these topics to correlate. So Go to the next slide, Brendan. I want to just give an overview of what happened in Briggs, because to fully appreciate and understand where we are, given the Supreme Court's decision, you have to understand how we got there and what was specifically before the court. Briggs was a case that came out of Susquehanna County. Mr. Briggs owned an 11-acre parcel. It was unleased. And on either side of this parcel, Southwestern had leased acreage and formed production units. The one unit, Southwestern drilled a horizontal well that was very close to the eastern boundary of Mr. Briggs' property. He alleged and argued that that well was unlawfully draining hydrocarbons from his unleased parcel. He essentially was arguing a subsurface trespass claim. Now, it's important to note that in front of the trial court, Southwestern argued that it did not drill underneath Mr. Briggs' land, that any hydrocarbons that may have been drained from his property was occurring naturally. You know, we didn't drill underneath his property. We have a well bore that we drilled, we stimulated it, and as a result of that stimulation, yeah, maybe some hydrocarbons drained from that unleased parcel. They allege that that activity, that conduct, was protected by the rule of capture. Now, in the trial court, go back for a second, Brendan, back that slide back. The trial court agreed with Southwestern and granted summary judgment in favor of Southwestern. Case is over. Mr. Briggs lost. Southwestern was arguing that the rule of capture was a total, complete affirmative defense, that it was a free pass, that just, no matter what happened, rule of capture operated to insulate them from all liability. Now, before we go any further about what happened in front of the Superior Court or the Supreme Court, I want to talk about the rule of capture. What the heck is it? You know, the rule of capture has been around for over 120 years. It's a rule of essentially non-liability. And it's premised on the notion that gas in its natural state is fungible. It moves around. You can't contain it. And when gas is trapped between two rock formations, you know, a common reservoir, the gas moves around. And if you imagine a checkerboard, and that each little block on that checkerboard is an individual leaf. And underneath all those blocks is a common reservoir. If you drop a vertical well down on your little red block, down into that common reservoir, it is going to drain gas from the entire checkerboard. From, you know, molecules from the entire reservoir are going to drain into that well. The rule of capture was adopted by the courts in the late 1800s to reflect that. That, hey, gas is naturally going to move around in a reservoir, and it's unfair and detrimental to the development of oil and gas if we hold that driller liable for trespass. As long as there's an important corollary of the rule. The wellbore has to be drilled within the four corners of your lease. It has to be drilled, as long as the wellbore goes straight down in that little red block in the checkerboard, goes straight down into the reservoir, rule of capture applies. But if the wellbore deviates and it bottoms out underneath my neighbor's parcel, the black square next to mine, that's a subsurface trespass. And the rule of capture has never insulated drillers from that type of a trespass. It's always based on all the well infrastructure being within a leased parcel. Now that's where we get to the intersection with modern drilling and hydraulic fracturing. You know, when a wellbore is drilled, part of the process is it is perforated, which is essentially a gun that shoots holes in the wellbore, and then it is stimulated with a tremendous amount of hydraulic fluid, and that is under pressure, and it goes out into those little holes, and it fractures the rock. It creates frac fissures. And in reality, instead of having an 8-inch wellbore, the process of stimulation it makes the effective wellbore width 100, 200 feet on either side. And hydrocarbons flow from those fissures into the wellbore. So that's where there was an issue with, well, if those frac fissures go underneath my property, is that a subsurface trespass? And that was at the core of Mr. Briggs' claim. He wasn't arguing that, hey, you drilled a well bore underneath my property, but he was saying the frac fissures that were created by your hydraulic fracturing operations, those go under my property. And this is an important fact, and the brief that Brendan and I submitted to the Supreme Court emphasized this next point I'm going to make. In order to hold open those frac fissures, the hydraulic fracturing fluid contains propane, little pieces of microscopic sand, and they hold the fissures open. So in essence, they really serve, they're no different than a wellbore. There's something that is artificial, something that the driller puts in a little spot and in a hole to keep that fissure open, to allow hydrocarbons to flow out. And that is the key of a subsurface trespass claim, is the placement of the propane in the fissures that might be under your land. Let's go to the next slide, Brendan. So Briggs loses in front of the trial court. He appeals to the Superior Court. And in April of 2018, the Superior Court, that's our intermediate court here in Pennsylvania, it reversed. It reversed the trial court and said, wait a minute, rule of capture is not an automatic affirmative defense. But the Superior Court's opinion was based on perhaps a distinction that was not valid, that when you have naturally occurring drainage, the rule of capture applies. But the Superior Court opined that when you have artificially induced drainage, i.e. the frac fissures that are kept open from propane, the rule of capture doesn't apply. And they kind of adopted a per se rule that said, hey, whenever time you're using hydraulic fracturing, the rule of capture is just simply not going to apply. And that was a win for landowners, but it was a step that no other jurisdiction in the United States ever recognized. The Superior Court further said that because the record was incomplete as to whether there was an actual trespass as far as placement of fluids draining from Mr. Briggs' property, it had to go back to the trial court. Well, Southwestern appealed. And in January of this year, the Supreme Court vacated the Superior Court's decision. Now, when a court vacates something, that's a big deal. It basically said the Superior Court's opinion is eliminated. It's removed. It doesn't exist anymore. And I think the Supreme Court actually got it right. The Supreme Court recalibrated the analysis to say, we need to focus on, was there a physical intrusion? And in order to establish a trespass, the plaintiff has to prove, hey, you put something underneath my property that shouldn't be there. And in the case of subsurface trespassing and hydraulic fracturing, the focus is always going to be on the propane. So when you frack that well, you shot propane into the frac fissure that's under my property. That's no different than that deviated well bore we talked about earlier. It's like drilling down that red square and it bottoming out somewhere else. You put something underneath my property. And the Supreme Court expressly rejected the distinction between naturally occurring drainage and artificially induced drainage. He said that's the wrong approach. We reject it. We're not going to adopt a per se rule that anytime there's hydraulic fracturing, the rule of capture doesn't apply. The court rejected that. The court instead is focusing and directing us as counsel to plead claims that you have to allege there was a physical intrusion under your property. If there was a physical intrusion, a viable claim for subsurface trespass will exist. You still got to prove it, but the rule of capture won't automatically operate to bar that claim. So that's the key takeaway, is that if there is evidence or reasonable belief that fracturing has occurred near your property line, that the frac fissures extend out from the wellbore under your property line, and that the driller has used propane to keep open those frac fissures under your property, that will establish a viable claim for subsurface trespass under the current status of Pennsylvania law. So the key takeaway is if you reside close to if your property line is close to where there is a lateral, and you believe that there has been fracturing that's taken place, and those laterals might be under your property, you need to contact council and get a petroleum engineer on board quickly so we can ascertain whether there's a viable claim. Typically, the frac fissures extend out about 200 to about 400 feet. That's the zone. If you're 1,000 feet away, 2,000 feet away, based on the cases that Brendan and I have worked on, it's highly unlikely that there are frac fissures under your property. The zone is about 200 to about 400 feet. If you're within that zone, and hydraulic fracturing has taken place, contact council immediately to evaluate whether there's a claim. So, subsurface trespass claims are alive and well in Pennsylvania after Briggs, but they do require evidence of an actual physical intrusion, and landowners can establish that by demonstrating through expert testimony that the propants are underneath your property, keeping those fissures open. So that's Briggs. Let's move on to the next topic, which is Act 85 and cross-unit drilling. As I said, this is going to be the hot topic for the next year, and I envision a significant amount of litigation on this. Brendan, take it away.
Thanks. So topic 2 relates to cross-unit drilling, and it functions or focuses on Act 85 of 2019. Although it was enacted in November of 2019, it became effective in January of this year. And as a result of all of the occurrences since January, this becoming effective really has kind of not got the attention that it deserves practically. But it really is something that could dramatically change unitization and landowners' rights. So philosophically, this is one of those situations where the concept of cross-unit drilling is not necessarily something that is bad for landowners. It's proposed as something that is a technique that will allow additional discovery and recovery of subsurface resources, that it will minimize the impact of surface development. Instead of a variety of well pads being placed, there could be a singular well pad with much longer horizontal laterals that access areas that have either been developed by existing wells, and there are areas where it just wouldn't make sense to put a new well, or really a clean sheet approach for unitization. It's based on advances in technology. As drilling technology improves and as the economics get better associated with it, and the risk is relatively mitigated, you don't, as a driller, necessarily have to incur all of the costs for site preparation, acquisition of sites. If you have an existing well pad, it makes sense to drill longer laterals from the well pad. So the concept of cross-unit drilling, longer horizontals, is something that I think Pennsylvania needed to recognize to make sure that laws and regulations here stayed up to date with technology. The problem is in the execution of the law, in terms of how the law actually addressed this concept and what it required and did not require. So this is just a quick exemplar of a rough outline of a cross-unit well. A variety of colors on the screen. The darkest red represents the cross-unit lateral. The lighter red colors represent unit boundaries. So you can see it goes from one unit on the north down to the south. So this is just a kind of a view of what it would look like. Previously, if you look at wells, the well would be drilled on a well pad, likely on one side of a unit, and it would continue to just short of the unit boundary, and then it would stop. So here, clearly, it shows the well crossing the unit boundary and continuing on. The nature of the existing unit, or whatever units might be assembled out of it, out of the new well probably provide greater context than just the overall length of the horizontal lateral, since drillers are the ones that assemble the units. So the statutory text that the General Assembly passed in the fall, which became effective in January, is the real kind of point of the problem that we see for landowners. And it's worthwhile to take a look at the text to really understand what's going on. So it starts with a general proposition that if an operator has the right to drill a well on separate units, they can produce a well that traverses by horizontal drilling more than one unit if the operator reasonably allocates production from the well that it determines attributable to each unit. And they can allocate production on an acreage basis for multiple units, provided that it has a reasonable correlation to the portion of the horizontal wellbore in each unit. That is problematic because attorneys live in the world of reasonable, and what is reasonable or not reasonable is really in the eye of the beholder. Essentially, this seems to vest the driller with the ability to simply say, I've determined that this is reasonable, ergo I am entitled to substantial, call it the benefit of the doubt, as to how I allocate production. As we'll discuss in a few minutes, that's problematic. The second point here is that the cross-unit drilling is allowed if the traversing well is not expressly prohibited by the terms of a lease. We'll get to that point in greater detail here in a few slides, but that is essentially a holdover from the General Assembly's enactment several years ago, which essentially said, look, even if you have a lease from the late 1800s where no one had ever contemplated unitization, unless that lease expressly prohibits unitization, it's allowed. So this is a topic that has been seen before in Pennsylvania that really has not been adjudicated up to the higher appellate courts, but it shows up here again. The second part of Act 85 deals with the location requirement of the 330-foot buffer zone that is waived associated with these particular wells and cross, essentially to allow a wellbore to cross from one unit to another. And then finally, there's a bit of a proviso at the end that says, this law will not allow you, to drill a cross-unit lateral, on property that is not under lease, and it does not automatically expand or diminish, so make larger or smaller the surface rights of an operator. So the statutory text is pretty basic. The principal problem with this, we believe, is beyond the question of can they do it or not based on what's in the lease text. It becomes an interrelated problem with the allocation in that if a horizontal wellbore is drilled that crosses two units, it's very unlikely that at the physical location where it crosses from one unit to another, it's akin to driving from Pennsylvania into Ohio or New York, where there's going to be a sign there that says, welcome to New York. There's not going to be a meter or anything to identify the volume or flow in the wellbore, most likely, from the different units. So what happens is all of the volume is essentially metered at one location, at the wellhead where it comes to the surface, and the operator will reasonably determine how much of that gas came from the different parts of the horizontal lateral that were in the different units. Why is
that important? Explain why allocating volumes of production is important, because that's how royalties are calculated, right?
Correct. So the issue becomes one of practicality and then an issue of legality, in that not all wells are necessarily uniform in the geographic area that they're producing hydrocarbons from. Technology has advanced, but there's not necessarily a guarantee that thousands of feet out in a horizontal lateral, the formation is identical to the formation elsewhere, that they haven't gone up and down in the formation as it has dipped, that the different take points where the hydrocarbons flow into the well are essentially pulling in identical volumes of hydrocarbons. And it also, as Bob discussed before, associated with the stimulation process, not all parts of the formation may respond the same to stimulation, that you may just have some areas along the wellbore where more hydrocarbons come from than other areas. But when all of it is rolled together, it becomes a problem when you don't necessarily know what hydrocarbons came from certain places. And essentially, this is a very, very simplistic view that shows a proposed method of allocation. And you have the long lateral in green, an area of perforated wellbore in red in one unit, another area of perforated wellbore in blue. And this is done based on an identification of the areas of the wellbore that have been perforated. But it assumes that the perforation is uniform, that the volumes of production and rate of production from these areas are identical, which isn't necessarily true. So the issue that it comes to, is the possibility of amending private lease contracts. Your lease will most likely have a unitization provision, and it most certainly should have a royalty provision. And this is really an area that I think landowners need to carefully study, because many, many leases that we have reviewed, they do not deal with cross-unit drilling explicitly, because the concept was not necessarily contemplated when the contract was signed. But they do provide specificity associated with how the royalty is supposed to be calculated, how it is supposed to be paid. So a concern is that we have an existing contract with a driller. The Constitution, both the federal Constitution and the Pennsylvania Constitution, prohibit legislative enactments to change contractual bargains between parties. There are a variety of tests that are employed, but it fundamentally gets down to what is the substance of the amendment and how does that impact anyone. So when the General Assembly in the creation of Act 85 says, look, this is allowed unless the lease specifically prohibits it, it seems to be an unnecessarily simplistic view of how the different provisions in a lease operate and what their significance is. So not only is that a philosophical modification of a contract potentially, but the whole concept of a production allocation, it's guesswork is really what it comes down to. It may be a greater degree of guesswork, but unless there is a specific measurement of the volume of hydrocarbons that come from the different units, it is what it's called, an allocation. So if a royalty provision, which many in Pennsylvania do, say that a royalty is based on the production from the, quote, leased premises, which is usually defined as the tax parcels or the reference to the deed, that's identifying the four corners of a place on earth where if production comes from there, you're entitled to a royalty on that. More broadly, if there's a unitization clause, it will expand that four corners of the leased premises and more or less say you are entitled to production from the unit. So when there is a well or wells that produce in a singular unit, the volume of production from that unit can be easily identified. It's the total volume of production from those wells. When a well goes across unit boundaries, we would submit you do not know how much gas is actually coming from a unit versus another unit. It's an allocation. But if the contract says you are entitled to a royalty based on the hydrocarbons produced from this unit, you are entitled to the hydrocarbons produced from that unit. And if the driller does not measure the actual hydrocarbons coming from that unit, it seems to be in conflict with the express terms of the contract that the parties agreed to. And that creates not only an issue, again, philosophically with the royalty and how it is potentially amended and an unconstitutional infringement on the right to contract, but the practical reality is it impacts the pocketbook and how much the driller pays. And it, in that sense, it creates a real issue in terms of enforcing the language of a contract as written. And if there's not a way to audit or to determine how people are getting paid and to make sure it's from their unit versus another, someone could be shorted or someone could get paid more than they could, but that's not what contracts may necessarily say. So we would submit that there are likely provisions in leases that expressly address and deal with the calculation of royalty, putting aside the question of cross-unit drilling. Like anything else, it comes down to money, and the contracts often do provide for how the money should be addressed and paid. So even if a contract doesn't necessarily say, you are not allowed to place this in a unit with a well that goes across unit boundaries, the lease may say, this is how you're supposed to pay me from anything coming out of my unit. And if there's no demonstration of what comes out of a unit, that's problematic under the contract. Additional issues which I think can arise are a lack of real regulatory oversight. The text of Act 85 is there. It's pretty basic. Other jurisdictions, Oklahoma is one for an example, where there's a much more detailed regulatory process in Oklahoma, public hearings, etc. In Pennsylvania, like many other things, it's left to drillers, good, bad, or otherwise. There's no agency overseeing these cross-unit wells. It really is still a matter of contract between drillers and royalty owners. And then there's also an issue associated with being held by production and operations. If there's a cross-unit well, what happens to your lease if they're not drilling in your unit, but they're drilling a cross-unit well in another unit? Are you held by those operations? What if they don't stimulate the part of the wellbore in your unit? So these are to be determined. There is a present case dealing with these issues in the Middle District of Pennsylvania, the Hortus versus Cabot Oil. It's in the very early stages, but it is something to look at because concepts of cross-unit drilling are part of that case. So it really is something that is present, and these issues are going to be hashed out, shall we say, in the present moment. Bob?
Yeah, I just want to add 2 points to this important topic. Prior to Act 85, many landowners who might be at this virtual town hall may have been approached by a driller asking them to sign a consent form allowing cross-unit drilling. Brendan and I represented a number of landowners that have been presented with that type of a proposal because the drillers implicitly recognized that the underlying lease did not authorize cross-unit drilling. So they were asking the landowners to consent. Act 85 negates the need to get consent. And that's the real danger here is the General Assembly really shifted the equilibrium in the favor of drillers because now drillers are saying, hey, look, I don't need your consent. I don't care what the lease says. Act 85 says I can do it. I'm going to do it. And that's where Brendan and I have been advocating on behalf of landowners saying, wait a minute, it's not that simple. When you look at the pooling clause and the royalty clause, when you read them together, they restrict and or prohibit what you're trying to do here because the pooling and royalty clauses set forth a methodology and a formula as to how you're going to calculate my royalty. Act 85 cannot unilaterally change or modify my lease. And if you try to do so, it's unconstitutional. So that's the takeaway from landowners is if you get approached by a driller who's just going to unilaterally implement cross-unit drilling, you need to take swift action. And you need to challenge and dispute their authority to do so. And you argue that, look, Act 85, whether it's constitutional or not, my lease has a formula and methodology how you're going to calculate my royalty, and you're not following it. So again, landowners need to be mindful of cross-unit drilling because it started off with just a couple of drillers, and Brendan and I are seeing now that it is expanding into almost every inventory of driller, all the inventories they're trying to accomplish it. So we'll keep an eye on the Hortus case as it winds its way through the Middle District, but all landowners need to be mindful of cross-unit drilling because if it hasn't happened yet, it's likely to happen in the next couple of years in your neck of the woods. Brendan?
So that takes us to topic 3. So it shifts gears a bit here towards lease expiration issues. These are not necessarily your typical lease termination issues that have been kicking around for years. These are some new developments that are worth noting because they seem to go 2 different directions. So the first one is Wilson versus Snyder brothers. This is the case that in the introduction, Bob indicated that it is controversial. We'll get into why, but it seems to continue to some degree a practice of continual confusion of what exactly the law is on a variety of topics in Pennsylvania. So this came out of Armstrong County. There were several leases from 2003. They had a somewhat unique and awkward term provision, allowing for just a 180-day, about 6-month primary term, and would remain in effect beyond that if oil and gas was actually produced or delay rentals were paid. So the primary term came and went. There was no well. So for the next years, the lessee, the driller, just paid the annual delay rental. In 2010, which would have been roughly 7 years after the lease was executed, there was a permit obtained for a vertical well, and amendments of the leases were executed. This is where things get a little bit tricky. As part of those amendments, there was a ratification clause stating the lessors, royalty owners, ratify the leases being in effect and not in breach, and it will remain in effect by its terms. So that was in 2010. In 2011, there was a vertical well that was actually drilled, and then thereafter some royalties were paid over 7 years after the lease was originally executed. There were other details that were alleged in the trial court that even when production began, it was inconsistent, that it stopped. In 2018, a lawsuit was filed. The landowners, as it principally relates to this discussion, they sought a declaration from the court saying, look, the lease expired because it wasn't producing, and the driller just couldn't continue to pay delay rentals to maintain the lease in effect. The trial court dismissed the lawsuit, said the landowners had not pleaded a viable case. It was appealed to the Pennsylvania Superior Court, and they reached a decision in January that rubber stamped what the trial court had done. And the Superior Court, they really focused on the ratification in 2010. And in the Superior Court, which is the intermediate appellate court, it said, look, when the landowners ratified or signed the ratification in 2010, they waived any claim that they may have had to dispute the non-validity of these leases based on the lack of production from 2003 to 2010. They also said, look, there's not a great degree of clarity associated with breaks in production after the well got started, so there is no claim here. The tricky part of this for practitioners and particularly for landowners is that the status of the law now becomes unclear, particularly because the Superior Court has determined that this case will be what's called a reported decision, which does have presidential value in Pennsylvania moving forward. So the principal issue that we see is that in 2011, the Superior Court, looking at century-old authority in Pennsylvania, in the case of Height versus Falcon Partners, said, look, you can't maintain a lease in effect by paying delay rentals without actually drilling. Because the rationale going back 100 years was you essentially wind up having a no-term lease, and it just becomes a perpetual option agreement versus a lease. And public policy does not favor essentially a lease that you can maintain in effect, never drilling, but just paying some money. The Wilson court here in this particular decision, they try to distinguish the Height case by saying, look, Height didn't deal with a ratification, so we don't even need to think about it. That's troubling because the issue here, we don't think that, as two oil and gas practitioners opining about the law, we don't think the appropriate focus should have been the ratification, because there's an underlying issue associated with, was the lease actually valid beyond the 180-day conclusion of the primary term when nothing was drilled? If drillers cannot pay delay rentals to maintain a lease because indefinitely, because it essentially creates an option, then there's a legitimate question if the lease ever entered its secondary term. And if when you execute a lease, the lessee, the driller, gets what's called inchoate title. It's not complete. It becomes complete title, a fee simple determinable to extract the resources when production is found. But here there was no production at the end of the primary term. So we think the analysis that should have been undertaken by the court, which really was not undertaken at all by the Superior Court, was a question of, was there a lease in effect at all beyond 2004 that could have been ratified in the first place? If there was no production, no effort at production or drilling, then even though the lease contemplated the payment of delay rentals, was that effective? Could that have maintained the lease in effect? And if the lease was not in effect, then ratifying the lease, we would submit, simply could not have happened. A secondary point is, a ratification is not a blanket catch-all for any and all conduct that ever happens. If you ratify something, to the extent that there could have been a valid ratification here, the day after you sign the ratification, what is the effect? If the ratification looks backwards from the date that you sign it, what happens the next day? And that's an issue associated with a lot of leases where years ago, there are amendments and ratifications proposed, or even in the current day. It may even be something if a driller says, look, I want to drill a cross unit well, and I want to have some piece of paper in my file that you agree with it. It may be styled as an amendment and ratification. And what it has come down to with this particular decision is a question of what is the extent or expanse of a ratification. Does it inoculate a driller as to all potential conduct, even going forward from the ratification date, or is it something that only looks backwards? Thoughts associated with this case, it seems to stand in contradiction to Height, which itself is based on very, very old case law in Pennsylvania rooted in public policy concerns. If this is a reported precedential decision, it injects uncertainty associated with what the law really is, because there are drillers that just pay without actually producing anything. And if the purpose of an oil and gas lease is to produce and exploit hydrocarbons, that's where the public policy angle comes in. That becomes an open question. Secondarily, what are the risks of signing any ratification? Or at a minimum, a need for a clear view and revision of what the nature and extent of any ratification that may be signed actually is. So it may not be that someone can rely on it and say, look, as of today's date, I will say that everything is okay. And that's what I believe this ratification does, because it's possible that it may be viewed broader than that and broader than a landowner or royalty owner may view when they actually put pen to paper. So this winds up creating substantial uncertainty. And we are over a decade into the shale gas era here in Pennsylvania. So there's a lot of decisions in Pennsylvania with a lot of dust on the books from the late 1800s, early 1900s that have to be modernized. But over a decade in, with a lot of money, a lot of property rights at stake, it seems that we're still dealing with some fundamental issues of what's a lease, when is it effective, which creates a concern. The second point.
Brendan, before we go on to the actual points, I just wanted to summarize. You go back one slide. The key takeaway from Wilson, as Brendan was saying, is a ratification instrument. If a driller approaches you as a landowner with a ratification, be very careful. Red flag flags should go up because ratification, we have always viewed ratifications as being strictly retroactive. They look backwards. The landowner signs it and is essentially saying, look, whatever issue there was, I am ratifying, there's no more problem. But it shouldn't be prospective. It shouldn't insulate from legal review or adjudication what happens the next day. And in Wilson, they signed a ratification. Okay, so maybe between 04 and the date of the ratification, I'm ratifying it, the lease may be in effect. But the very next day, if there wasn't hydrocarbon production, a very strong and persuasive argument should have been made that the lease expired. The ratification only looks backwards. It can't grant a blank check to a driller going forward. And that's where I think Wilson simply got it wrong. And we all have to be wary of how Wilson is construed by other drillers as we go forward. Brendan?
So on the general theme of questions of Pennsylvania law and what it really is, just to quickly touch upon an interesting case out of Warren County, SLT Holdings versus Mitchell Energy. You know, the facts here are kind of facts where you look at it and you say, well, what were they fighting about here? You know, leases were signed in the 1980s. You know, they had a drilling requirement for multiple wells. Only one well was drilled on each one of these parcels. And then from 1996 to 2013, neither of the wells produced any gas. You know, there were no royalties paid, nothing happened. Eventually a lawsuit was filed in 2014 to say, look, these leases are kaput. The trial court found in favor of the royalty owner. And they said, look, 16 years of inactivity is a long enough time for us to conclude that you're not interested in producing anything here. The driller had argued that the reason that there was no production was that during the 16 years, the driller just couldn't make money producing. And the trial court just put that aside and came back to this whole concept, and they write that, you know, if that justification stood, then leases would go back to option agreements, and the implied covenant to produce hydrocarbons would be practically insignificant. So, you know, one would look at it and say, yeah, that made a whole heck of a lot of sense. You know, if you're not producing for 16 years, then, you know, you're really not interested in doing anything. It appealed to the Pennsylvania Superior Court. The Superior Court affirmed the trial court, which in our view was no big surprise. But was somewhat surprising was the Pennsylvania Supreme Court in April decided to hear an appeal of this case from the driller. And the issue they agreed to hear was, did the Superior Court, which is the intermediate appellate court, commit an error granting judgment against the petitioner on certain counts where a well in each parcel was drilled and the wells were productive, and there was no testimony about good faith decisions associated with production. And the court asked the parties to further review you know, the doctrine associated with implied covenants to produce, et cetera, and abandonment. And this is interesting because the abandonment doctrine has come up recently in Pennsylvania almost as a parallel track to a lease termination case. It eventually, or, you know, it terminated for failure to produce, but it has a slightly different angle because abandonment requires demonstration of an intent as well as action. And the decision below did deal with abandonment. And it could have been that when you get into whether a well is producing or a lease is producing and paying quantities, there is a question of the good faith decisions of a driller. And it may have been that the courts below simply said, look, doing nothing for 16 years shows you weren't interested in doing anything. So there's no conceivable way that you could provide testimony that you were doing something in good faith. Look, you abandoned. But the Supreme Court has decided to take up that issue, and it involves, you know, from the trial court, questions of was it abandoned, and by failing to drill additional wells and produce, was the implied covenant to reasonably develop the hydrocarbon formations? What is the impact of that? So we don't necessarily know, looking in from afar, associated with what the Supreme Court is going to do. One would hope, from a landowner's perspective, that the Supreme Court does not take a radical step and say that this case has to go back for development about why the driller didn't believe he could make any money for a decade and a half from these wells. Our hope would be that the doctrines of abandonment, the implied covenant to produce, can be clarified to a greater degree in Pennsylvania law, because these are concepts related to oil and gas that really have not been substantively developed for decades. And in the case of the implied covenant to reasonably develop, 100 years. So these are things that are implicated by this case and are interesting, and will be an educational experience to see where the Supreme Court goes here. And one just hopes that it doesn't go into the question of whether these leases remained in effect when nothing happened for 16 years.
Yeah, my concern is, for one, the Superior Court got it right. The Superior Court's decision in SLT Holdings was the correct one. There's typically two theories you pursue in a lease expiration claim. Either the automatic termination rule, you get to the end of the primary term, there's no production, the property interest automatically terminates. Abandonment is a secondary theory that, instead of arguing about property rights and fee simple determinable, abandonment is, hey, look, you didn't do anything for 16 years. You abandoned whatever property rights you had, and there's no discussion of the automatic termination rule. And in the Superior Court, we believe, chose to go down the abandonment path for two reasons. One, it appears to be a theory that's catching some momentum with the Superior Court, because there's been some other decisions. And number two, the underlying lease in SLT Holdings had a default clause, that you had to give default notice that there was a default, and the driller had been arguing that, hey, look, you can't terminate this because you never gave me a default notice. To bypass that whole argument of the interplay between the automatic termination rule and the default notice clause, I think the Superior Court just said, look, abandonment. You didn't do anything for 16 years. The lease is terminated. I hope the Supreme Court doesn't alter or modify the essence of that holding, because I think that's a good decision for landowners. We're starting to run out of time. I'm going to briefly talk about the last topic, which is always everyone's favorite topic, and that's the deduction of post-production costs. If you have an oil and gas lease in Pennsylvania and you're getting paid royalties, you likely have run into this issue, and that's the driller deducting post-production costs from your royalties. Now, many royalty clauses in Pennsylvania are what is known as a market enhancement royalty clause. And this is a clause that originated from Oklahoma, found its way up to the Marcellus, and is now in a lot of leases. And it basically says, look, if there is, you can't deduct any cost from my royalty unless and until the gas is in marketable form. In other words, driller, you have the responsibility to put my gas in a marketable condition, whether it's decompression, hydration, gathering, moving it to a pipeline network, processing the gas. You have to make it ready for sale. You have to make it marketable. And until you do so, under a market enhancement clause, you can't deduct. Now, drillers recently have been taking the position that the gas is marketable at the wellhead. Say, hey, you know what? Yeah, you got a market enhancement clause, and I understand I can't deduct anything until the gas is marketable, but hey, guess what? The gas is marketable as soon as it comes out of the ground. Therefore, I can deduct everything. Decompression, compression, dehydration, processing, gathering, all. And that's really a disingenuous argument. Next slide. There was a case down in Kansas, Super Clerk versus Oxley, and it was just decided on a motion to dismiss back in June. And the issue was could the driller deduct processing costs that were incurred after the gas was pulled out of the ground before it went to the interstate market? In Cooper-Clark, 97% of the gas was sold on the interstate pipeline network. And although the percentage might be a little bit different, that's true here in Pennsylvania. Gas is not sold at the wellhead. Marcellus gas is sold on the interstate pipeline network. The driller has to move the gas from the well pad through a gathering system, to a processing facility, and then it connects with an interstate pipeline network, and that's where it is sold. Well, in Cooper-Clark, the plaintiffs argued that, hey, you're deducting processing costs that are incurred prior to the gas being delivered to an interstate pipeline. You can't do that. Processing by nature is making it a marketable product. It's not marketable. It's not able to be, it can't go into an interstate pipeline until it's processed. And the driller's response was, well, at the well pad, I'm actually using some of that gas to fuel equipment, and some of the gas is also being used for home heating, residential use. And because there's some use at the well pad, there's a market for it, therefore it must be marketable for all purposes. Fortunately, the Kansas court rejected that argument and said, no, you have to look at where is the intended market. Where are you actually going to sell the gas? And here, 97% of the gas is sold on the interstate pipeline network. And it's not marketable until you get it into a condition that allows it to be sold on that pipeline network. That is a big decision for landowners. Now, it is a Kansas case, so technically Cooper-Clark isn't precedential here in Pennsylvania, but the rationale, the reasoning, the logic of that decision should be espoused by Pennsylvania landowners. If you have a market enhancement clause, Cooper-Clark provides you the roadmap as to how to argue the deduction being improper. Gas is not marketable here in the Marcellus Shale until it is ready for the interstate pipeline network of where it is sold. So, costs incurred between the well pad and that interstate pipeline network, gathering, dehydration, compression, processing, those should not be deductible because the gas isn't ready for its intended market until it reaches that interstate pipeline. I would further argue that even once it gets to the interstate pipeline, it's not marketable until it gets to the actual final sales location. And therefore, the transportation costs incurred to move the gas to that final sales location are also not deductible. But the takeaway here is very clear and very compelling, that gas has to be, the marketability of gas has to be viewed through the lens of where it is intended to be sold. Gas is not sold typically in the Marcellus region at the well pad. So what's happening at the well pad should have no bearing on whether the gas is marketable. It's marketable when it gets to the interstate pipeline network. That's where it's sold. That's the critical point of where we evaluate the marketability and whether it's a marketable sale. Brendan?
Yeah, I think that the idea of looking at marketability based on the intended market, it makes sense because it injects some certainty into it. Otherwise, I think there's a problem that it becomes subject to abuse if you can just label gas as being marketable because you say so. You could invent your own market, even if it is just we'll call it a sham or a pass-through type transaction for the sake of a transaction existing to prove a point. The gas is priced on the interstate pipeline network. That's where the large volumes are sold. There's transparent pricing. There's index pricing. The Henry Hub pricing that you see all the time comes from the interstate pipeline network, one particular location on it. So, if it looks to where the driller is intending to sell, where it intends to make its money, and in that way, that is the thing that identifies what the marketplace is. It makes sense. And it really goes, it doesn't insert itself into the driller's calculus of how it conducts business. It just simply says, look, if that's the chosen market, so be it. That's what we're going to look at for these market enhancement clauses. It makes a lot of sense, and it's transportable to Pennsylvania with these market enhancement addendums.
I think the argument that the driller made in Cooper Clark was disingenuous. The fact that some gas is used for home heating and some gas is used for fuel equipment, that doesn't create a market for gas. It's just they were able to use it in its raw form for those particular purposes. But that's not where it's sold. So trying to rely on that evidence to establish that it's in marketable form doesn't hold water. I think Cooper Clark, the court got it correct, and I think it is the rationale utilized by that court. We should be able to argue that here in Pennsylvania if you have a market enhancement clause. In addition, even if you don't have a market enhancement clause, Brendan and I have seen a trend whereby drillers make this marketability argument anyway, and that they don't have to, they can deduct costs as soon as the gas is in marketable form. And so Cooper Clark will also be useful to landowners when confronted with that argument made by the driller, even if you don't have a market enhancement clause. This concept of marketability is going to be an issue that is litigated and debated in this year as well as in next year. It's one of those topics that's not going to go away, but I anticipate more litigation on the issue of marketability. You know, we got a question from someone about the Chesapeake bankruptcy, which I'm sure is on a lot of people's minds, and you know what to do about if you're a landowner and you're receiving royalties from Chesapeake, or you suspect you want to challenge deductions or the pricing, the commodity prices. The key is needing to file a proof of claim in that bankruptcy. And Brendan and I are following the Chesapeake bankruptcy and can assist landowners filing a proof of claim to preserve that argument that either the royalties were improperly calculated or the deductions were excessive and improper. Brendan, thoughts on Chesapeake bankruptcy?
Yeah, it's an unfolding issue. Certainly a lot of filings there. A lot of people are owed a lot of money. There are, you name it, in terms of different types of issues, lease termination issues, royalty issues, deduction issues. So it's very complicated. I think part of the sense was for some degree of almost a prepackaged deal, if you will, in the bankruptcy that certain lenders would just agree to make certain debt go away. But I think an issue that really wasn't appreciated in the whole thing is the question of what is Chesapeake's leasehold? What does it have, and what is the value of the obligations to different royalty owners? And there's separate issues associated with midstream and gathering contracts, like Bob was talking about, associated with the marketability issue. And those contracts may remain. So it's very complicated. But certainly we're ready, willing, and able to help. There's no shortage of landowners who have issues, royalty owners who have issues. But the key is not to sit on the sidelines and hope that something is going to come out of the bankruptcy, because most likely it is not, unless landowners, royalty owners, in whatever form or fashion, become involved and assert their own rights.
We also got another question from a participant. What are the remedies and practical benefits to a landowner who challenges a cross-unit well after it is in production? I think the key issue there is, are you getting paid correct royalties? And our concern has always been that when you have the two units and there's a wellbore that goes through unit A and it ends up in unit B, if they don't perforate unit A, will the landowners in unit A get any royalties? And what happens is essentially that they just grant a perpetual free subsurface easement that allows that wellbore to go through unit A to access unit B. That's the concern here is, are you getting paid royalties on production, and is it being calculated correctly? So the benefit is really, they don't have the consent to drill a multi-unit well. And they shouldn't have the right to unilaterally modify your lease. You know, it goes back to the core issue that the right to pull your lease is not some common law right. They only have the right to pull your acreage if it's granted in your lease. It's a contractual right that is granted because it can be abused and it is right for overuse. And the same is true with cross-unit drilling. The idea is to give consent if it's not in your lease, but make sure it's done equitably and fairly. And as Brendan pointed out during his presentation, there are real concerns on whether a landowner is going to get paid properly and accurately for a cross-unit wellbore. Brendan, your thoughts on what remedies and benefits are available to a landowner who is after a well has already been drilled?
Yeah, so I mean, after a well has been drilled, the theoretical idea of can a cross-unit well happen, that ship has sailed. So what it ultimately comes down to is something that we run into all the time. Any royalty owner that probably has had an interaction with a driller knows, you know, mysteriously to drillers, the language of the lease, the black and white text on that piece of paper is gospel. It is the end-all, be-all of everything. So if a cross-unit well has been drilled and royalties are being received, I think the question at that point becomes, okay, driller, I'm seeing volumes of hydrocarbons produced that I'm being paid on. What does my lease say about what volumes I'm supposed to be paid on? If my lease says from my property or from my unit, driller, show me that the volumes that I'm being paid on come from my property or my unit. And if you can't do that, then you're breaching my contract. Yeah, that's what it ultimately comes down to, in my view. You know, the constitutional issue is interesting. Certainly, it's better for everyone if before a well is drilled, an amendment can be reached, and then everybody knows what's going on. The conduct is approved by a contract. But after it's already done, it really fundamentally goes back to, am I being paid properly based on what the contract says? And if the lease contract doesn't say, you can be paid based on a reasonable allocation of what we believe might be coming from your property or your unit, well, then an allocation without actual measurement of what's coming from the unit doesn't seem like it complies with the contract.
Well, any other questions, comments? We're happy to address those. The presentation is available. You can access it electronically, and we're happy to provide that to you. Thanks for joining. Hope it was helpful. Hope you're able to take away some information that will allow you to evaluate and monitor your own lease and keep abreast of developments here in Pennsylvania oil and gas law. We are going to do another year-end summary. So look for our oil and gas bulletins alerting on the exact date, and we'll talk to you soon.